Those damn sex toys, man.
Yeah, I mean they're out there, bro, and hey, everybody needs them, man. A lot of people need them, man. It's like there's a money making industry, man. I mean, have you seen the markup? I mean, I don't know if you've been to a sex shop recently, man, but I have a friend of mine.
What was that
Actually,
thing you went, Rodrigo?
there's actually an intern that is a
Uh-huh.
mechanical engineer that interned for me,
Uh-huh.
and he has him and his family is a family owned sex shop. You know, family owned.
Your grandma in the sex shop selling slanging dildos?
Nah, man. I didn't see the grandma there, man, but I'm sure she probably had a good attitude about things. but no, man. But yeah, man. I mean,
Okay.
you ready to go?
Yeah.
So the goal for today's conversation and podcast really is just about helping people better understand some of the ins and outs of patent law and as it applies to the average inventor trying to bring their ideas to life and protect their ideas. And so today we have a very, very special guest, Derek Fahey from the Plus IP firm. His website is www.plusfirm.com, specializing in all aspects of patent law, trademark, copyright, and happens to be one of my preferred partners here at Lime Design. We've worked with Derek he's one of the first attorneys that I've worked with and had the pleasure of working with. So thank you, man. I want to thank you for making the time to meet with me and to chat a little bit about, what it is to, get your product protected and all the ins and outs of, patent law. And thank you, Derek.
Yeah. Thanks, Rodrigo, for having me. And, I love working with the Lime Design team. And I really appreciate the opportunity to share what I know with, people that are listening to the podcast. So thanks for having me.
Cool, man. So I figured it's kind of just a loose kind of style. Let's just ask each other a couple questions. Have a couple questions I prepared for you, and if you have stuff that you want to add in there, if we want to go off on a tangent, it's all good because it's just about having like a very organic conversation about different things about patenting and product development in general. So you ready for the number one? Number one's going to be a low, nice and easy one for you. Ready?
A softball toss?
Softball. Ready?
Okay.
All right, Derek, what got you into patenting and IP law?
Wow, that's a long question. But quite honestly, I actually never even knew what patent law was until I was exposed to it. I always loved math and science, and I was always a naturally inquisitive person. I like taking things apart and putting them back together, understanding how things worked.
Yeah.
And I was an engineer for about five years before going to law school. Mm-hmm. And I realized I did not want to be an engineer inside a manufacturing company, because I actually was that at one point. I was an engineer in the field. I just liked understanding how things worked just because of my inquisitive nature. Mm-hmm. Long story short, I got told about patent law. I thought it sounded cool. And then I applied for law school and got into a good law school. And luckily, as luck would have it, I love what I do. Mm-hmm. And been doing that now for 10 plus years. And that's why. Hopefully that was helpful.
Yeah, absolutely, man. So 10 plus years, man. That's running your own business for 10 plus years now?
This will be my 10th year. Well, this will be my 10th year in business coming up. June 4th, 2023 will be my 10th year in business, in my own business, and then over 10 years of being a patent attorney.
So you're about like 73? Is that what you're saying?
Oh man, God! I actually found my first gray. I'm over 40, and I found my first gray hair this weekend, and I stared at it for a little bit, and it was just like, man, is that really a gray coming in?
Oh man. And all right, here's another good one for you, man.
Okay.
How many patents and trademarks have you worked on, do you think? If you could, ballpark it.
Oh, thousands. To give you an idea, we file probably 300 trademark applications a year.
Okay.
And we file, as far as patent applications, both on the utility side, which I'm sure we'll get into later. We probably file at least 1 to 2 a week. I mean, yeah, sometimes more, sometimes less, but a lot. This is what I do, you know. Well, let me flip it to you, Rodrigo. How did you get into helping people develop prototypes? I don't think I've ever asked you
that. Man, I mean, actually, a lot of similarities to what you were saying, where I had this natural, you know, I was better at taking things apart sometimes than putting them back together. But it's like the curiosity of trying to figure those things out, understand why things work the way they do, and you know, had some I don't know, I guess some artistic skill that I, you know, kind of found a sweet spot between engineering and art, right? Really, I was looking into architecture and that kind of stuff when I first started out. And but yeah, I don't know, man. I was walking by the Art Institute of Pittsburgh, and I looked through the window, and they had all sorts of really cool products that was in the window, showcasing some of the student work. And man, I mean, I just knew it was just so cool, man. I just knew, man. And at almost like the same week, I remember I was a kid at the time. Well, a kid now, man. I'm 45 now. That was when I was like 22 or 23 when I was looking at the art, when I was that day in time, right?
Yeah.
And man, it was like a week later, I sold my PlayStation. I had a PlayStation 3 and an Xbox. I sold it all because I was like, I'm getting rid of every single distraction. And I was like, you know what? I don't care what my family says. This is a career that I think would be cool to go into. And I think I could learn a lot and have fun in. And I took out a loan for myself. I knew they would pay for me to go, man. But I was like, nah, I'm going to pay because I know I'll take it more serious if I pay for it.
Yeah.
And never looked back, man. You know, I worked for other companies for about 11 years or 12 years before I started my own. And, you know, now it's just, you know, no turning back, man. I love it more and more.
You know, what's interesting is when I think I saw some of your original sketches for some product that you're working on for a client many years back. And I remember seeing the artwork and remember thinking, like, wow, like just seeing you work as an artist, not only as the engineering side of things, I see the artwork, your hand sketches, and I'm like, wow, like you have a really cool gift, and it's awesome you get to share it with your clients and your colleagues. So it's pretty cool.
Yeah. And the reality is that it can be taught, it can be learned. You know, you have to practice it. Like, because I started Art Institute without, you know, one of the reasons why I got into the Art Institute is because they didn't require that. All they needed is money for me to go in there. You know what I'm saying? If I had to have a portfolio, which most art schools require, right? So yeah, man. But thank God they didn't have a portfolio requirement, because I didn't have a lot of stuff to show. I had like some photography, some ceramic stuff I did, some woodwork stuff I did. But man, yeah, man. But that was a lot of fun, man. And yeah. So, all right. So I guess we can jump into some patent related stuff.
Let's do it.
So why are patents so important to have?
You know, that's a great question, Rodrigo. You know, first off, you don't need a patent to sell a product, right? There's plenty of products out there that people sell that people make money on, right? But why does everybody want a patent? Well, patents provide a competitive advantage when you're in the marketplace. So what a patent is a legal document that prevents other people from making, using, and selling a particular invention or product or method of doing something or software in the United States. And so it allows people to it prevents people from actually selling the product. So while you don't need it, it does provide a huge competitive advantage. That's why when you hear people talk about Shark Tank, they're always asking for, do you have a patent or not? Because investors many times will want to know, hey, can we have a competitive advantage, or is every person going to be, you know, coming into the marketplace and competing against us? So that's why.
Got it. So for maybe some of the newer people that don't understand the differences in patents, I mean, I guess we should probably just get that out of the way, right? Talk about the difference between a utility patent, a design patent, and what a provisional versus non-provisional patent.
Oh, those are great questions. Okay, so first off, design patents protect the ornamental features of a design. So you have some cool products back there. I see the World Cup trophy in your background there. And a design patents protect the ornamental features of what a product looks like. So the shape of a statue or a shape of a planter, what it looks like. Okay. A utility patent protects the functional features or the functional aspects of an invention, whether it's how a certain software code works. You can actually prevent the functional features of a system using software. You can protect features for different types of devices that are functional, how things operate, how things work with each other. Those things are protected with utility patent applications. They're, as far as utility patent applications, you can actually have a provisional patent application and a non-provisional patent application. So a provisional patent application actually never matures into a patent. It actually is not a patent. People always say provisional patent. That's actually not using the term correctly, but a provisional patent application lasts for 1 year. Okay.
So it's an application. It's not really a patent. It's an application to start a patent, basically.
Yes. And why is a provisional patent application so important? So the entire world, every single country in the world since 2013 is under the first to file system, So if you're an inventor and you don't file your patent application and somebody else files a patent application that's similar to yours and gets a patent for a similar product like yours, the first person to file the application will get the rights to the invention, generally speaking. Okay. So the entire world operates under a first to file system. So the provisional patent application is used many times to kind of reserve your rights to get a filing date so that you can potentially develop the invention in the future. The provisional application is really great with people that are coming to you, Rodrigo, that they have a little bit of an idea. They think they have a cool concept, but they need to flesh it out, and they want to test the market. It allows them to file an application, get that early filing date. That's so important because the entire world operates under this first to file system. And then they can develop the product, develop the features, understand what people want, if they actually like the product or not. Maybe there's some things that need to be tweaked out. And then within 1 year, it only lasts for 1 year, you have to file a non-provisional patent application. And a non-provisional patent application is the application that eventually will get examined. That actually will get examined with the U.S. Patent and Trademark Office. So provisional lasts for 1 year, will never become a patent unless you file a non-provisional within that 1 year. And if you don't have to wait a year. Let's say you go to Rodrigo's office and he makes a product within 6 months. You put it online and you sell 1 million units on Kickstarter, and you say, "Hey, this is a good idea." You can file immediately. You don't have to wait, but it just reserves the right, and you get that filing date, and you can say patent pending for up to a year with the provisional.
Nice.
Did that answer your question?
Yes, that was a great answer to that question. Thank you.
Okay.
All right, man.
Let me ask you a question.
All right, go ahead. We want to play ping pong style. Let's go.
Yeah. So when people come to you, are you telling them, like, let's consider filing a provisional patent application, or are you saying, hey, listen, you have an idea in a napkin. This is not going to work. Like, you can't have this particular, device, or this particular, this is not going to work. We need to change things. It's a good idea, but we got to change things. So, like, what are you telling clients when they come to you with an idea that needs work? What do you do?
All right. So I'm one that believes that we should work with the IP teams early in the process, right? So that being said, I like them to think about the product first. Let us do our initial conceptual design work, and then come back and get you involved so that you can review because basically what we're doing is we're helping digest the client's idea, right? We're helping them think it out a little bit so that they're not just coming out with the first thing that comes out of their head, but you also think about it with some professionals. Say, hey, yeah, that can work like that, or maybe you can use it for other applications as well. So we're trying to help figure out how we can maximize what the client gets out of the product that they're creating. And maybe it's creating multiple versions of it, maybe it's adding different features that they hadn't considered, or giving it a styling that they didn't consider. There's so it's also about getting them options for their design of their product, for what it's going to look like. And
you know what, you said something that kind of just reminded me of something. Is one of the jobs of a patent attorney, just like you kind of like flesh out the ideas, and we'll say, hey, this is good for this application, but what about this? You could use this for this particular application as well. One of the patent attorney's jobs when they're drafting a patent application is to draft what's called a claim section. And the claim section is the heart or the nucleus of the patent application, in such a way that, we're not just trying to patent one little particular device that they came to Rodrigo and Rodrigo gave them. We're trying to capture a whole lot of different types of intellectual property. So we may have a broad scope and a narrow scope. So we're trying to capture as much IP as possible, so that if someone tries to copy it, they would still be infringing on their idea. They can't do that legally. So just wanted to kind of add that into what you were saying there.
Yeah. I'm going to share my screen real quick here.
Okay.
Let me see if that's showing right. Is that going right? Can you see this okay?
The process, yep.
Yeah. So I like to refer to this in general when it comes to creating a product. So when a client comes to me, let's say that they woke up one day and they had this amazing idea, and they did some quick research online. They didn't find anybody that was doing anything exactly like it. And, I normally like them to do like a quick Google patent search or a Google, see if you can find what you're talking about online. And if you can't, then that's it's a good sign that that you might be onto something. So typically, right? Can you guys see the cursor here?
Yes.
So concept development is the first stage of the problem of the project, which is defining the problem, surfacing potential problems, researching, looking at the technical aspects of the product idea, looking at how we're going to make it work both mechanically and what it's going to look like aesthetically, right? So that's what we come up with in the first phase here. By the time, and this normally takes us about 4 weeks or so to go through the stage, through the different stages of this process, the first part
process.
Of the process.
Yeah.
So right here, we have a pretty good idea of what the client's looking for. And we've then taken the idea and, grow it out a little bit. You know what I'm saying? Like think outside a little bit of what originally we were thinking about, and then dial it back in with a selected direction. So we'll typically come up with 2 to 3 different ways of doing something. Some things there's lots of ways to do things, and some things there's less ways of doing something, right?
Mm-hmm.
Does that make sense? That's one of those, you don't know what you know, but you know what you didn't know. It's like,
there's a rap song from there somewhere. There's a rap song there somewhere. But to your point,
right here. So right after concept development, right after we've done like our first, even like, it's honestly like halfway through our concept development is like when we typically like to involve our patent attorneys into the development phase with us. Because we've had some time to think about it and do our research on it so that we can speak intelligently to an attorney that, you guys need us to be quick with the info and so we try to digest it down so we can just get to it, right? To get to
you know what? You kind of, I tell clients all the time, before you do anything, and again, you don't need a patent to sell product, but if Googling is so important. I mean, there's actually a website called Google Patents. It's actually patents.google.com. And you can search keywords for what you're trying to do and see if there's patents out there. And I always tell clients, the first step after you write it down and after you start developing the concepts, or maybe even before that, is to see what's out there. Because you can obviously, if you're hell bent on selling a product without a patent, you can do it. You can do it. You just have to be aware of that and know the market and know you can actually make it happen. Because, the patenting process is not a short, inexpensive process. It provides a huge competitive advantage, but at the same time, you gotta know what's out there before you spend the business risk, which is money at this point, right? Into developing. So yeah, I think that's really good advice, Rodrigo.
Yeah. Coming back into chat just a little bit more about the process here. After we get our provisional, normally we like to have our clients file provisional patent right here. And this graphic is being updated as well, guys, because it's hard to squeeze everything in, but we're tweaking it. So right here is going to be another bubble, and this one's going to be called provisional patent. Because it's normally a good time to get involved with the patent attorney. And then after we've done 3D and engineering and we've prototyped it 2 or 3 times, or whatever was necessary for that project, then we would suggest doing the next layer of patent protection, which is going to be a utility patent.
How long does that take from so you file a provisional patent application, and now you're doing the 3D modeling, right? Like how long does that take for the viewers and listeners?
Sure. So every project is very different. Typically, we're prototyping within the second month or so, a month and a half, 2 months, we'll start prototyping. There's 2 to 3 rounds of prototyping. So you can expect it to take about 4 months, 3-4 months to develop the idea.
Mm-hmm.
And then, there's other aspects of the project that we need to look into as well. Like if you see on the bottom here, we have our branding and marketing efforts that need to be done. Every idea needs to have those efforts done for it, by somebody. So, making what the brand looks like, and that leads into another thing that needs trademarking, right?
Mm-hmm. Yeah.
So, brand and logo design.
Yeah, that's a great point. And just, I have so many questions for you. Every time I see this graph, I have more and more questions for you because it's a really good one. Mm-hmm. But why 3 or 4 different prototypes? Like, why do you need to go through that?
Because no prototype is going to be perfect on the first shot. In general, it's just no prototype is perfect on the first shot.
Yeah.
We're going from a sketch on a paper to a 3D CAD, 3D model, right? And then from there, obviously we try to make it as close as we can, but once you actually 3D print it and you have it in your hand, then you can feel if that tool, for example, feels right? Is the ergonomics correct? Does it, could I make it the handle a little bit wider? Should I make it a little bit thinner? Should we add more weight to it somewhere? Should we remove some weight, make it longer? There's a lot of different changes that can happen, but just analyzing it from the visual aspect, right? Like just by looking at something on a screen, you can't really capture it. Yeah. When you touch something, it becomes a whole, you can analyze it to a whole nother level and understand right away, I need a bigger finger groove for my fingers to sit on, or I need some rubber right here so my finger doesn't slip. So,
well, let me ask you this. This is a little off topic here. You think like augmented reality or anything like that will change your business where you're no longer doing prototypes, you're actually doing like virtual AR prototypes to do that process eventually? Like, do you think how far do you think you guys are away from that?
No, there's already softwares that you can work in VR, and there's different softwares that I can, you can have like a QR code printed on a piece of paper, and I can show the client's 3D model on my phone, for example, and zoom into to like get into the 3D model, really dig in. So I think that VR and AR is just going to help make that easier for us.
Yeah.
And I can see myself sitting here with the client. I probably won't do everything from scratch with him, right? Because we still need time to do our analysis and do our research and come up with some thoughts first on what would be cool, what would be appropriate, what would make sense for that client's product. And there's some stuff happening with software like Midjourney and other like AI software where you can say, draw me a hammer as if designed by Leonardo da Vinci, mixed with the style of Mark Newson, who's a designer, right? Or something like that, right? Yeah. So you could use a keychain, a chain of words to
Yeah.
explain to the algorithm, to the whatever the software, so that it can then look through all the pictures it knows and put
Yeah.
different options of what it looks like. So I experimented a little bit with that, and I definitely see it being something that I would put into play as well, just at least to get some thoughts out there to see what the computer says, and then we can select the style we like and then go from there.
Yeah.
But further than that, beyond that app that I just kind of went off a tangent there.
Yeah.
VR
I think it's a DALL-E, right? That's a DALL-E.
There's different ones, man. There's one called Midjourney that I have there's a lot of them now. They'll have
Really?
like a $30 a month subscription, and
Yeah.
they're basically using the platform. What was it?
It's not DALL-E 2.
No, there's some like engine, like a server that they use that you just run from there. I forget what it is. But anyways,
by the way, interesting topic, right? So who owns the rights to the artwork that's created from like AI software?
I'm not sure, man. I'm not sure, but it's going to create a ton of. It's going to tell me.
In the U.S. right now, it's the person using the mouse. Like
Really?
the courts have decided that, like, if you have artificial, so an inventor cannot be a computer; it has to be a human. Like, it's got to be human. Person that creates your artwork has got to be human. It's got to be he or she or they, them, whatever the case may be. Right? It's got to be a human. Can't be a monkey. It's got to be human.
Okay, so can I make an app that says I want to search every combination of everything that's been designed before and everything that could be designed in the future and get a copyright on every single thing?
Well, first off, if you create that app, that'd be badass.
I mean, but it's not too far off from what's already talking about. We're just expanding how deep it goes,
Yeah, I mean, well, first off, that's the software itself could be patentable, like the functionality of it. If you said, hey, I'm gonna have this app that has this much computing power to generate this particular answer within like a certain period of time, like, that's no joke, man. That's tough to do. So that software could be patentable, and Rodrigo Lima would be the owner of intellectual property because he's the inventor. Now, like, if Rodrigo created, if you said generate all this artwork based upon this information that I put in there, the software can't be the owner of the software can't be the creator of the artwork. Okay, it has to be Rodrigo because you're the one telling it do this and that, right? So it should be Rodrigo be the owner, not the software.
Copywriting is going to get crazy, man.
Think about that. Yeah, man, it's going to be a totally different thing. And the courts are already deciding it. They kind of were seeing this, and the courts are saying, got to be a human. Got to be. It can't be a computer. So it's going to be the person that's putting the, like, I think anyways, that's saying, hey, mix a skeleton with a Star Wars plant version, and you're going to come up with like or mix a unicorn and a Marine soldier in the DALL-E type style stuff.
It could lead to a lot more things being patented, I guess, because it's so much easier to combine things now.
Well, I mean, honestly, I think where the IP lies is going to be is just people like writing the software. Like that's kind of cool. Even though a lot of it's open source, but the use of ML and AI to generate new things, that's where I think it's going to be. Like, hey, using a cluster algorithm to tell me what is the best restaurant I should go to on Friday night in West Palm Beach, right? That kind of like writing that software is gonna, if it has some sort of just non-obvious and new, could be a patentable. I mean, Facebook has got all these weird, funky patents about that listens to you, like years they use they use different algorithms and they listen to keywords and they have to like enjoy or love, and then after the keyword it'll listen to what you're talking about, like Bahamas or orange juice, and start sending you ads to your Facebook or Instagram's feed because you said love, and then you said something right after it, so
Wow, man.
it's already patented, so it's not like nothing new. It's kind of cool.
That's insane, man. Let me look at my list here. Let me pull back a little bit, man, because that's some good stuff there. Oh wait, actually, so we just touched on a little bit the subject of copywriting.
Yeah.
Right. So when would somebody actually want to use a copyright?
Well, honestly, copyright is protects like software code or works of art, right? So think books, photographs, right? It's actually, legally speaking, it's anything fixed to a tangible medium. And you actually have copyrights as soon as you actually take a photo or print a photo or do some sort of artwork or art or label, like some cool design for your logo in certain cases. As soon as it's fixed to a piece of paper or any sort of medium, whether it's digital or not,
okay,
the creator has the rights to it. Okay, the author has rights to it,
and we actually have to file something to have the rights. It's not automatic.
Well, actually, it is automatic.
Whoa,
Okay?
whoa!
It is automatic, but catch-22.
Yeah.
All right, you can't file a lawsuit until you actually file and get a registration. So you have the rights, but you can't do anything with them, which makes no sense, right? But you do have rights, and you should actually file sooner than later, because if you file sooner than later, you actually get attorney's fees and costs. So let's say you have a cool logo that is on the internet, and you have a registration for the cool logo, and someone takes the logo from you. If you have a registration, you can file a lawsuit and tell them to take it down, and you could potentially get attorney's fees and costs and statutory damages, which basically means you don't have to prove damages, which is awesome, and get paid for the artwork that you created. On the other hand, if you don't have it, then you got to file an application before you file a lawsuit. You don't get attorney's fees and costs potentially. So that unlike patents, right? So unlike patents, where you have to file an application or you will never get rights to it. Okay. Copyrights technically exist as soon as you actually fix it to the tangible medium. Also, trademarks as well. Trademarks, once you start using it, so let's say you have Lime Design. Okay. Lime Design is well known in the South Florida industry for producing great work, right? So you actually have trademark rights to Lime Design in the geographic area you use it, even if you don't never file for it. But if you don't file for it, there's some issues, because what if there's a Lime Design in California? Okay, you're not using it in Florida. So trademarks also exist once you start using it and people recognize the mark Lime Design with you in a certain geographic area. But it's always better to file. But unlike patents, you do get rights for copyright law.
That's cool. It's good to know.
Yeah, it's kind of cool.
I do have my trademark, by the way. I had it trademarked, I don't know how many years ago. All right, here's a good one. How do you know when to spot a trademark? A design patent from a utility patent. This is something I did when I used to work at a tool company called Ironbridge Tools. This is one of the companies that I spent probably 5 years working for these guys.
Yeah.
So how do you know if this is a design patent or a utility patent?
Okay, very easily. So you can see there on the design patents, the letter D. There you go. It's kind of coming in and out there, but design patents have the word D in front of it. Okay, so D, the number D. So if you can see that on there, it says D. All right. Whereas utility patents, they don't have a D. All right. So you'll see a number on there. If you see a year on there, so if you see like 2010 or 2020. That's a patent application publication. It's not necessarily a patent. So instead of the D, if you see like a year and then a slash like 2022 or 2020, it's a patent application publication, not necessarily a patent. And going further, if you see PP, that means planned patent. So for example, you can patent cannabis strains. You can patent cannabis strains, or
what's your favorite strain?
What kind of strain? Honestly,
Slickster, you're getting out of this one, huh? All right.
Oh man, the one that pays, I think, is the right answer, man.
What was that?
The one that pays, but honestly, in the cannabis world, they're doing a lot of cool things, man. They're doing high CBD content. They're doing high CBD content, low THC, low CBD, high THC, whatever you want. You know, they can adjust the different ratios of the chemical compositions to affect how you want it. You know, which is super cool.
Yeah, how's yeah. Here's a question for you. When would a client actually use a design patent? Because I get a lot of inventors. So all right. So I guess the preface of this question is that there's a lot of, in my opinion, there are some patent attorneys out there that aren't always in looking out for the best for their clients. There's a lot of invention mills, and instead of getting like a stronger patent for their clients, they'll just get them something like a design patent. The client thinks he has this strong patent, and really he just has a design patent. This is something that I see with a lot of Invent Help and Davis, all these like big invention mill type companies that are, one of the ways I look at it is like, okay, if you call a design company and they have 100 salespeople and 10 designers or one designer, like that company's not really about that. You know what I'm saying? So I think one thing to be careful, and a big differentiator, I'll just throw this out there since we're already on this tangent, is that when it comes to product development, there is an invention promotion company and there is a product development company. And that might sound very similar, but what it is that an invention promotion company is typically a company like an Invent Help or Davison or something like that, where they're saying that, hey, we're gonna do a virtual prototype for you. We're gonna do an animation, and we're gonna take it out to a bunch of different trade shows, and we're gonna share that with all these companies, and we're gonna try to get your license, somebody to buy your idea from you.
Yeah.
Right. And so the difference being that they're promising you that they're going to try to sell your idea to somebody, and it's a no promises. They're, hey, we're going to try. It's going to be great. We're going to make you a millionaire. And then on the other side is a company like Lime Design and some other product development firms, where our focus is not so much on the marketing, more on the actually developing the idea and prototyping it, engineering it, so that you actually have something to sell at the end of the experience with us.
Yeah. That's a great point. I tell clients they have to be really careful with invention promotion companies.
Mm-hmm.
It's not what you do, because, I mean, inventors they have their baby. They think their idea is fantastic. And many times there are some fantastic ideas, but there are some people that are okay with taking advantage of the inventors and trying to sell them a bag of goods that's never going to happen, and it's going to sell them this pipe dream. And yeah, you're right. You got to be really careful when you're dealing with invention promotion companies, and you should ask really specific questions. There's actually a statute for invention promotion companies. You have to ask, you're supposed to, and they're required to give you by statute, how many products have they put out? How many licenses, and there's all these specific questions, and I could share with you, Rodrigo. And I tell clients all the time, you got to ask those questions, because if they're making money for one inventor out of 10,000, like, is that really a good number? Or if they're working with 10, if they're making money for one inventor out of 50, that's a lot better number. And it's good. It's just good to know that.
I think what happens is that like a company like that, it's really easy to like laser focus in on the inventors that have this dollar bills in their eyes, that they actually are using this invention as a golden ticket.
Yeah.
Right. I mean, in reality, man, I get a lot of people like that. They think they're going to make $1 million. It's going to take 6 months, and they're going to invest $10,000 to do this.
Yeah.
Right. When reality is you're going to spend 100 to 250K over the life of 2+ years to bring a product to market, develop the product, prototype it, manufacture it, ship it, get it into Amazon, and actually out into the world and get sales. It takes time, and time.
Yeah.
There's a cost to every piece of getting it done.
Yeah. Would you say you're almost like an outsourced like research and development kind of? Because that's kind of how I see you. Is helping, almost like a research and development department for small businesses that don't have that
Yeah.
aren't, you know, a Medtronic or Boston Scientific, these huge companies that have a dedicated squad of people. You're almost like a individual R&D. Would you see yourself kind of like that?
Yeah, we are basically a turnkey solution for funded startups. And I'm going to use that word, funded startups, because I get a lot of people that, you know, they reach out and they, you know, there's something to be said about expectations, right? Like an inventor reaches out and they expect to get their idea out into the world for, like, call it 5K, 10K.
Right.
And the reality is that the cost to develop something becomes greater the more complicated and the larger it is, right?
Yeah.
And sometimes the smaller it is. If it's something really tiny and minuscule and it's something that's hard to make, then it could be more, right?
Yeah.
So it's very difficult for me to quote projects too, because every project is so different.
Yeah.
You know, but
Yeah. Okay. Well, back to the question about design patents.
yeah,
All right.
yeah.
So design patents.
Took a tangent there.
Yeah, that's all good. So design patents are really effective when you have a cool looking product, right? So like a product that you're like, wow, that is cool. You ever go to a store, Rodrigo, and you're like, man, that is a cool looking bottle. Like, wow.
Yeah, yeah.
You ever do that? Okay.
Yeah, well, you see something and you can't help but to say, hey, that's pretty cool. Yeah, I mean,
it looks
I'd
cool.
buy that or whatever. You know?
Yeah, I mean, I know I've actually bought stuff because a logo looks cool, or you know, the shape of a bottle looks cool. There's a round, you know, there's actually like a round shaped suntan lotion bottle that it looks cool. It sticks out. You know, that's the best use of a design patent, is for a product that looks cool. If you're trying to protect the functional features, how it moves from A to B and how it actually clicks together, it's probably not a good use of a design patent.
Yeah.
You know, now you can actually, that said, you know, sometimes in certain cases, design patents can be used to protect certain shapes for functional kind of features. That's a more complex kind of thing. And generally that's done when there's a low probability of being able to get a utility patent, and they're trying to lock down some competition, lock out some of the competition by protecting that particular design. And larger companies will do what's called patent clusters. They'll file one application, get a patent on a particular type of intellectual property, and then they'll say, okay, now we have a patent on this particular device. How else can we protect it? Maybe there's only one particular way that this particular thing will work, you know, and they'll try to lock in the design with using that. That's a different way that you can do it too. So, yeah.
So, I mean, I didn't want to talk too much about cost, but I am going to throw you a stumper, dude.
Okay.
Ready?
Yeah.
How much would it cost to patent your product to the whole world?
Oh, man. That is very expensive.
Unpack that.
Yeah. So, all right. So first off, we talk about patents. Now, the reason why that was going to be very costly, this can be very costly. And in fact, I'm not even going to give you a number because it's over 100,000, probably over 200,000. Okay. And the reason why it's so costly is because when people come in and say, oh, you know, I want to patent everything across the entire world, you know, what I try to tell them is, listen, you know, realistically, that's going to be very costly. And very few companies do that. You probably have your big five, like Apple's and large, you know, medical device companies will be doing that. Why is it so expensive? Because in the patent world, you have to get a patent in each jurisdiction. So you have to get a U.S. patent. You have to get a patent in Mexico. You got to get a patent in China, right? You got to get a patent in some of the African countries. Okay, so when clients, I gave a quote recently, and a lot of this is government fees. You get a patent in the United States, you can't apply in other countries. In fact, there's this system called an application called PCT application. PCT stands for Paris Cooperation Treaty application. You can do it, and a lot of companies are larger, you know, I call them larger, smaller companies of like 100 to 200 employees or above. They'll actually file in multiple jurisdictions, but what they'll do is they'll file a PCT application first. They'll get a patent in the US first. and then they'll file a PCT application to reserve the rights for most of the countries in the remaining parts of the world. The PCT application allows you to file in, I think, like 153 countries or so. But every time you go into different jurisdiction, you gotta pay the fees, you gotta pay the government fees, you gotta pay maintenance fees. So it can get very costly. I would say probably, I mean, if you're looking at every 153 countries, definitely over $200,000.
Dang.
It's very, what I tell clients is like, realistically, where are you going to be selling it? And then where are you probably going to be trying to make it?
Yep.
So you want to at least prevent people from making it in that country, right? Maybe it's China, maybe it's India. And then also where are you going to sell it? Maybe if you're selling it in Brazil, or, you may want to lock down the countries that you're selling it in, as opposed to some other country that you're never going to sell in, so to speak. You know?
I get a ton of clients or potential clients, right, that, they want to lock their product in. They're so worried about people stealing their idea. Yeah. That's one of the tough things about invention in general. It's like, it's hard to know who to trust, right?
Yeah.
There's so much fear about, so people are going to steal your idea. They're going to copy it, this and that. And I mean, I honestly think if somebody really wants to copy your idea and they have enough money and a desire to do so, I think it's going to be very hard to stop somebody, man, unless you're patented in every single country. And then it's impossible, but who's going to put a couple $100,000 to protect a product in every country? So right now, and I know that there's companies and people that do this. You can, let's say the product's on Kickstarter, right? You see a company, let's say a company in Fiji or something. Let's say they see a product that's on Kickstarter, or he bought it, or somebody's purchased it in the store or whatever, right?
Yeah.
He went to America, purchased it in the store, checked it out. You see the patent number. You see that it's not patented in France or Fiji or wherever it is that you want to sell.
Yeah.
I mean, is it illegal to then go ahead and do that? It's legal, right?
Yeah. I mean, if you see a patent in the United States and you want to go sell it in France, and there's no patent in France, you probably can do that. You probably can do that in France, right? But you can't make it in the US. You can't make it in the US, okay? You gotta go make it in France, right?
But I could make it in Vietnam and then have it shipped to France, maybe, or whatever.
Yeah, right? you could, It's
That's
difficult,
hard, man, to really protect.
I mean,
it's very difficult, man.
Well, first off, that could happen, I guess, right? But the reality is the U.S. is the biggest economy in the world. I think it's the second biggest, and behind China, I think, or first or second, I'm not sure, right? Yeah. California is the biggest. California is actually, I think, the third or fifth biggest economy in the world. California, the state of California, okay?
Small tax.
Is people are going to want to buy here. We're consumers, right? We're consumers in the United States. So you're probably going to want to get US and where you're going to probably going to make it. And yeah, you're right. If your product is so great that people are trying to copy you, at least try to enforce it in the United States where you can actually get damages and you can control it. I mean, this podcast would be going to people across the world, but the reality is they're probably going to be making and selling it, at least selling it in the United States. So stop that,
So what would you do? What would you do if it was your product and you have a US patent, you have a PCT, you have a Chinese patent, right?
Yeah.
And then somehow the product ends up in the UK.
Yep.
I mean, what do you do?
Quite honestly, initially, you hopefully are seeing how it's selling. If it's selling well in the United States, chances are it probably going to sell good in the UK, right? And I think you just got to do cost benefit analysis to see if it's worth it. I mean, if your sales are, $1 billion a quarter, all right, then do in the UK, and you're seeing in your sales numbers a certain amount of units in the UK, and you're like, maybe probably going to be okay to do it in the UK. But I think you got to let the sales tell you the answer, and also your sales, and also where do you have the connections? Do you have connections in Tonga? Do you have connections in Vietnam? Like, who's actually going to be helping you out with this? So I think you got to look at where am I going to sell? Where do I have connections to like make it sell? Where are my customers from? I mean, right now, people are I have clients, you probably see it, Rodrigo. People are selling products all over the world. I mean, I buy stuff in ties from UK on Etsy and all these different platforms. I mean, they're selling. I mean, if you have cool products, people are going to buy it. So I think it comes down to where are my customers? What does it make sense business wise for me? Which a lot of people don't think about.
Mm.
If you're selling 1,000 units, but you're only making 20 grand a year, like, is it worth it in all these jurisdictions?
Right.
I don't know. I would say no, but you just got to make, at the end of the day, it's a business. And you got to try to make
this, bro, because like if the inventor or startup spends too much on patent protection, sometimes it'll choke out the the momentum, and you won't be able to develop the product.
Yeah.
And also vice versa. You know what I'm saying? You spend too much on development, then you don't have enough to protect it. So that has to be part of your strategy.
Yeah. One of the things I always tell them is, have you like done any market research? Do people want this product? I'll say this, but like I had a client many years back that had this interesting idea about what it was a product. It was actually it's like a sex toy. It was like a $15,000 sex toy. It was going to cost like $15,000 for the sex toy. And I had to ask her, I was like, what's the market for a $15,000 sex toy? Like, I mean, like, there's a lot of other things you can do with $50,000 instead of a sex toy, right? I mean, just in the sex industry, right? If you think about it, but like, who is going to be buying this, And I think you got to really, that's where you come in, I think. It's kind of, you can say, hey, listen, like, we got to change the plastics, or we got to change something, Those damn sex toys, man.
Yeah, I mean, they're out there, bro. And hey, everybody needs them, man. A lot of people need them, man. It's like there's a money-making industry, man. I mean, have you seen the markup? I mean, I don't know if you've been to a sex shop recently, man, but I have a friend of mine.
What was that thing you went, Rodrigo?
Oh, there's actually an intern that is a mechanical engineer that interned for me, and he has him and his family is a family-owned sex shop. Family-owned.
Your grandma in the shop selling slanging dildos.
No, man. I didn't see the grandma there, man, but I'm sure she probably had a good attitude about things. But no, man. But dude, the markup is insane, man. Like, I'm saying, like something was like, I don't know, it's like $30. It felt like everything was overpriced, but everything was selling, dude. So I don't know, man. So
we joke about it. We have gotten patents, both utility and design patents on sex toys. It's talk about like design patents, cool shapes.
Right.
Sometimes like the shape of something that's a great example. Like certain shapes of dildos and different things, that's actually patentable, right? So design patents. So just go back to the design patents, bring it all back around. But seriously, I know it's a big industry, and that's actually one of those ones where you would do the market analysis. Hey, how many products, how many units of the sex toy are we selling in Japan? How many units are we selling in China? And just kind of go through the analysis and say, is it worth it? And design patents are less costly than utility patents, so it may be worth it in some places. But yeah, man, sex toys is not a joking industry. But did you really have an intern that was like a family?
Yeah, family has it's in like Hollandale or something, man. It's what's the one right here off of 95?
What you tell me? Which one is it?
I forgot the name of it.
Scarlett's?
Yeah, Guilty Pleasures. Right next to Scarlett. Is that right next to Scarlett?
What's that?
No, man, it's on 90. It's right next. I know what you're talking about. It's next to that. It's right next to it.
All right. For those who don't know, Scarlett's is a strip club, like a gentleman's club. It's kind of like a nightclub as well. So.
The South.
I don't know about that. Oh, you talking about like spicy or spice?
Man, well, anyways, so it's very close by. If you want the number, call me. We'll figure it out. So this guy, anyways.
Like, number one. Hold on, let me get you right now.
But yeah, man. So yeah, they've done well, man. Family run, been running it for a long time, making money. They wouldn't be doing it if they weren't making money with it, you know. So
Yeah. Yeah, that's I don't know how we got into sex toys, but yeah, we
I
got,
don't
you
know.
know, is there next
Yeah,
question?
let's move on. So speaking of sex toys, how many patents do you think that we've done together, man?
Man.
I'm gonna
How many issued patents?
issued patents, actually patents that we've gotten notice back and
I'd
awarded.
probably say 20.
Yeah. I was gonna say 20, 30, somewhere in there.
Somewhere in there. I think there's a lot more applications or
Mm.
like at least searches we've done, to get like
Yeah.
one thing we haven't talked about yet is doing like searches and opinions
Mhm.
after clients do that initial Google search and after you kind of flesh out the idea,
Mhm.
we do an opinion about whether or not the invention's patentable,
Mhm.
right? And a lot of times it's not patentable and they may come back to you and say, I still want to sell it, right?
Yeah.
And sometimes they don't want to move forward with that, but you know, so we work with, I would say I have worked on clients probably maybe 30 to, I don't know, a lot, I would say, and in full disclosure, just so everybody knows, I don't make any money on any of the clients that I give to you, and you don't pay me any money for the clients that I give to you. I like giving you clients because I know that how when they come to you, you do things a certain way. You're straight with them. You're going to tell them like it is. You're going to
Mhm.
respond to their emails. And I know that's what I do, and I expect the same from you. And that's the feedback I've gotten from the clients that refer to you. So I just want to make that clear. There's no money being exchanging hands. It's just I know you're gonna do a good job. That's why I send clients your way.
Yeah, and same, man, reciprocally, man. Like I know that you'll take care of my clients the same way that I take care of them. I expect a high standard from the people I do business with, and that's why I have you actually at the top of my preferred IP attorney list, man. I
Yeah.
mean, there is a little bit of favoritism from my side. I'm not going to BS. You're one of the first patent attorneys that I've worked with. We've been doing business for probably close to 10 years now or so. You know what I'm saying?
Yep.
15 was the first patent that we did together for one of my personal projects.
Yeah.
The simple socket. It's an electrical magnetic plug that myself and Zach Silvers worked on. And and that's that was 15. So yeah, 7-8 years working together. And man, I'll definitely be referring you more and more. And I think these podcasts are really good way of sharing information, man, because
Yeah.
Standard marketing where you're sitting there just like selling features and this and that. I hate that shit, man. Like
Yeah,
I
man.
want to be able to just talk real and just
Man.
look. Hopefully, people learn something from this conversation we had, and they know that they're dealing with two people that really care about their craft and have their reputation, at stake when it comes to anything to the products that we work on.
Yeah.
And want to make sure that we're always doing our best, man. Make sure we get as many products out into the world as possible.
Yeah. Same here, man. Enjoy working with you. Appreciate you having me. Yeah, I just, we got to figure out how we go take a field trip to that sex shop. You know what I mean? Yeah. All right. That's enough.
Come on, man. We'll set it up.
No, I'm just kidding. But
Man, have you ever heard of Amazon?
what's that?
Amazon, bro. It's a sex shop too, man.
Yeah, Amazon is one of the beasts, man. It's one of those things that nobody wants to sell on Amazon because the margins they're just so tough, and Amazon is like this, but people just have to. If you're not selling Amazon, I mean, I'm a great example. I hardly buy anything off of Amazon. I'm almost like first thing I do, Amazon.
Yep.
I'm willing to pay $4 extra for so that it gets in my house within 24 hours. So.
Yep. And then if you had to go drive there and go pick it up, think about how much gas and time you're wasting to do that, right?
Yeah.
But I'll tell you what, man, we've had some good success setting up some of our clients on Amazon platform.
Really?
Yep. One specific,
Cool.
Kemet Farms, man. This guy, I don't know how he even found me, man. I mean, our marketing's pretty good because he found me out from North Dakota. He's a farmer. They were selling seeds for like bird seeds and stuff like that, right? Critter food. They were selling at 10 cents a pound to wholesale. We're now set. We set up their website, the Amazon. We did custom
Sure.
packaging. We did like everything, but created custom packaging for them, like to make it look high end, right? And with a reusable pouring bag with a handle and everything. So really made a nice premium product. They're selling their product at $185 a pound now.
Wow.
So that's 18.5x.
Wow,
Right?
that's great. Yeah, that's amazing. That's
Dude,
awesome. I didn't know
obviously, Amazon takes, it's like 30% or something.
Yeah.
Right? It's
But
every
still,
product.
Wow.
They're still making $15 a bag, where they would have made, $1 or $2 for selling it wholesale.
Yeah, Amazon plus, yeah. I mean, that's where they're searching,
Yeah.
And what's cool, I don't know what the brand is, but that's why a good, strong brand is so important. I mean, if you have a crappy brand and people you're looking for, Lime Design is actually the Lime Design Lime part is a great brand, because lime, which is a fruit, has nothing to do with product development, So branding is so important when you're dealing with Amazon, making sure you have a strong brand.
Yeah, this is can you see the screen?
Yeah.
This is the product here. We had the bags designed. It was made overseas, made in China and shipped over, and then everything's filled here in the States.
That's awesome.
Yeah, but
You guys from North Dakota?
Yep.
That's cool.
And it's so cool, man, because every product I work on, it's somebody's dream. They don't understand yet the whole ride when they come to me, but our goal is to help them understand the whole ride. You know what I'm saying? See the whole picture, because when people come to me, they're so focused on just getting a patent and just getting a prototype that they're not understanding the whole reason the prototype is to figure your idea out, think your idea out, test it out.
Yeah. Well, this is a great podcast, man. I'm looking forward to the next one. Did we get through all the questions? Or are we good?
We got through the questions on my side, man.
Okay.
I appreciate
all right,
that.
Good stuff.
Let's do this again, man, and we can maybe pick another topic, or kind of almost pick an area or a specialty area or something like that. So before you go, so Derek, what languages does your team service your clients?
Okay, English, Spanish.
Mm-hmm.
What else do we have? English, Spanish. My partners and English, Spanish, and Japanese.
Okay, cool. Sure you didn't make that up on the fly there, man? I don't know. You were like,
for a second, I had to think of, we have my partner's paralegal is Japanese. I'm like, is she Japanese or Korean? So, but you got it.
Yeah, cool. Nice, man. And you represent in Florida. Obviously, you're big in South Florida.
Yeah.
But I know that you also have a New York.
Yeah. So
office.
Yeah. So great question. So because I'm a registered patent attorney, I take a bar exam above my bar exam, like the state bars, to become a patent attorney. So I can represent clients in any state before the USPTO. And so we have clients in California, out west, Washington State, New York. I'm also licensed to practice law in New York as well, and DC. But generally, we can help people get patents in any state. And in fact, I'm actually flying to New York this week, coming up week, to meet with some clients. I flew last week to meet with some clients in Washington State. Washington State's beautiful, man. I love that place.
Nice.
Yeah.
More stuff. Cool, man. Well, Derek, listen, I'll definitely be in touch so we can set up to do this again, man. We can get some of the viewers to comment to some of the questions that they have, and we can maybe answer those in the future in another podcast, and where we can dig deeper, man. And
cool. Yeah. You think people are gonna watch it?
I think so, man. Yeah.
Okay. We can edit out some of that sex talk a little bit. I may have gone a little overboard.
Yeah, I don't know, man. It cost extra. Nah, man. I don't think anything was inappropriate, man. It was fun, dude. And
can we stop recording though? Is that cool?
Yeah, we can stop now.
Yeah.
All right. Well, here, just Derek, before I stop recording, thank you again, man. I really appreciate it. We're going to go back in and put some information showing your logo and your contact information on there.
Cool.
And we can, make it easy for people to get in touch with you. And
Yeah.
yeah, so I'm going to stop the recording. Thank you so much, man. And let's do it again, brother.
Cool. There, bud.